Good afternoon or good morning to all of you wherever you may be. Welcome. Welcome to Ethical Considerations and Open Source Investigations. This is a new format that we're trying out here at the European Society of International Law. We're calling them the ESIL Dialogues, the opportunity to organize online events beyond our annual conferences. First, I should have introduced myself. I'm Dalek Hernandez. I'm the president of the board, and I just wanted to come out and welcome everyone here today for this. I'm not chairing the event. For that, I'm delighted to pass on the floor to Tamar Megiddo of Hebrew University, who will be chairing. Thank you very much, dear Tamar, and I wish all of you a wonderful event. I'm sure this is going to be really, really interesting as a discussion.
So much, Glider, and good evening, good afternoon, good morning to maybe to some of you who have joined our webinar on ethical considerations in open source investigations. My name is Tamar Megiddo, and I'm a senior lecturer at the Hebrew University of Jerusalem and an affiliate of the 3 Generations of Digital Human Rights Research Project. The research project, led by Professor Yuval Shani and funded by the European Research Council, is co-sponsoring this event together with the European Society of International Law Dialogue Series and AJIL Unbound. AJIL Unbound is the online companion of the American Journal of International Law. Source investigations and the evidence they produce are revolutionizing multiple aspects of international and domestic law and politics, and even war. Over the past decade, open source investigations have served to identify and prosecute persons responsible for shooting down Malaysia Airlines flight MH17, leading to the death of 298 passengers and crew members. They have served the assassins of Russian commander Stanislav Razitsky to track him down through running data posted on a popular app and shoot him. They have served as the basis for debates over the responsibility for an explosion at the El Ahly hospital in Gaza, with mainstream and social media comparing various user-uploaded videos, geolocating and analyzing missile trajectory. In February, AJIL Unbound published a symposium on digital evidence, edited by Professor M.J. Durkee and myself. The Unbound Symposium addressed several aspects of digital evidence's impact on international law, including in the context of refugee status determination, the settling of interstate disputes, and international criminal prosecution. One issue addressed in the symposium is our main topic today: the ethical dilemmas that open source investigators face and what resources and guidance are available for researchers. One characteristic element of the field of open source investigations today is that researchers are not only those associated with government agencies, prosecutorial authorities, or military intelligence, but also individuals, citizen journalists, political activists, academics, and others. Each of these organizational affiliations, or the lack thereof, may prove immensely important in the choices of which events are investigated, in the availability of information and whether it is accessible to researchers, in the degree of cooperation received from subjects of inquiry, and in the existence of legal and professional norms in place to guide a researcher in their work. We will dedicate the next hour or so to address these and many other questions that arise from open source investigations. We're going to begin the discussion with 3 rounds of questions that I'll present to the speakers, and conclude with a 4th round, or hopefully several of them, of questions from the audience. So please feel free to drop your questions using the Q&A function at any point, and I'll collect them and ask our speakers to address your questions in the final round. Before I begin, I'd like to convey my thanks to Dr. Veronica Fickfack of UCL, who organized this event for ESIL, and for Maria Grazia de Siena for her support on behalf of ESIL, to our speakers, and to all of you for joining us today. Let me present our speakers. Dr. Alexa Koenig is co-faculty director of UC Berkeley's Human Rights Center, director of the center's investigation program, and a research professor at Berkeley Law. She co-founded and directs UC Berkeley's Investigations Lab, which explores how new and emerging technologies are affecting human rights practice, and trains war crimes investigators and journalists around the world in digital open source research methods. Ronald J. Deibert is a professor of political science and the director of Citizen Lab at the Monk School of Global Affairs and Public Policy at the University of Toronto. Siena Anstis is senior legal advisor with Citizen Lab. Prior to joining Citizen Lab, she worked as a litigation associate at Morrison & Foerster in New York City, and clerked for the Honorable Mr. Justice Cromwell at the Supreme Court of Canada and at the Court of Appeals for Ontario. Jakub Dalek is a senior network and security researcher at Citizen Lab, and his research is focused on website and network censorship. And finally, Dr. Matthew Gillett, who will join us slightly late from a UN meeting, is a senior lecturer at the University of Essex and a UN special mandate holder on the working group on arbitrary detention. He prosecuted cases before the international courts in The Hague for over a decade and now heads the Essex Digital Verification Unit. So for our first round, I'd like to ask the speakers, and I'll call on you according to my own Zoom order, if you could each briefly introduce yourself and tell us of one ethical dilemma that you've encountered in your work or your research that is representative of the kinds of questions you'd be interested in discussing today. So Alexa, maybe I'll call on you first, if that's okay.
Of course, and thank you so much for having me this morning, this afternoon, depending on where people are, and to all the organizers. So as was already mentioned, I teach at UC Berkeley and also run our investigations program as well as our investigations lab. Just to give some context for one of the ethical dilemmas that I'll raise, our work is really done in service of three sets of partners. So we work really closely with human rights organizations, groups like Amnesty International, with whom we started our investigations lab, also Human Rights Watch, smaller grassroots groups. Second group would be investigative reporters and other journalists. So we're often providing a lot of the digital open source content and doing verification work to support their reporting. And then we have a third bucket that we kind of broadly call sort of the legal accountability space. Our work really started in this area, working with the International Criminal Court, thinking about back in 2011, 2012, how there were new forms of digital information coming available that could potentially support or in some cases disprove what survivors were saying had happened in their community. And I think there was a real need in the legal space to begin reckoning with the ways that increasingly visual information, but also other forms of digital information were really available to help build the evidentiary foundations of really critical cases. So one of the challenges I think that we've really had has been looking at how these three different areas of practice really have different professional codes of ethics, and how while these areas of practice are really united by a set of methodologies. So how to discover this kind of information in digital spaces, how to verify its accuracy and reliability, and then of course, how to present it to greatest effect. I think at the same time, we're really doing this for different end purposes with different standards that have to be met and different ways of thinking about what constitutes proof or truth in this kind of a space. What we have been trying, the other challenge that I think we really face that also feeds into what I'll say a little bit about during the next hour on ethics has been the fact that we work with a mostly student population. We have a number of professionals on our team, and we do professional level work and train war crimes professionals, journalists all over the world. But at the same time, our primary kind of bread and butter and investigations teams are students, and they may range in age from 17, 18 years old up to their early 30s. So what we're trying to do at this point is create a professional pipeline into practice of people who are really well trained in not only the underlying methodologies, but also with a sensitivity to holistic security. So physical, digital, psychosocial security considerations that can be either different or more acute when working with digital content. And then of course, as part of that, the ethical components. Since I've been talking way too long, maybe I'll give one quick example. The very first ethical dilemma that we faced outside of how do we keep these students relatively safe and set them up for sustainable long-term work was we were about to produce our first report looking at a series of attacks that had happened in Syria. And, like many groups, we had geolocated primary videos that were really critical to our analysis, and we had drafted into the report those geo coordinates. And this was probably back in 2015, 2016. We quickly realized, thankfully, before we went to publication, that the geo coordinates would likely give away the location of the people who, of course, had shot that video, and could make them a target for retaliation or further attack. And so I think thinking about this tension between a value in the open source investigation space of transparency, and particularly transparency of methodology, which may encourage the revealing of geocoordinates and other potentially sensitive data, with this understanding that the security risks that we're creating could be quite acute, and then we need to know how to moderate those, and how we think of this not just as a binary of publish, don't publish, but who do we provide this information to, under what conditions, and to what end? Thank you.
Thank you so much, Alexa, for starting us off with these fascinating comments. And I'm going to ask the Citizen Lab folk, they would each take one question on behalf of the group. And this time, Jakub is going to do that for us. So please.
Yes, thank you. And thank you to ESIL for hosting the event. So I'm Jakub. I'm a senior network and security researcher at Citizen Lab. And our contribution to the journal basically deals a lot with digital accountability research and the unique challenges and dilemmas that are faced by this work. So for those that are unfamiliar, Citizen Lab is a cross-disciplinary research institute based at the University of Toronto. And we look at the intersection of communications and information technology, human rights, as well as security. So this is the kind of work that Citizen Lab has been undertaking since 2001 to kind of give some sense. We do a lot of work around application security, malware security research around that. And in terms of dilemma, I think basically one of the dilemmas that I'll talk on behalf of my group is basically one that perennially happens within our work. And basically it is the dilemma when we actually publish an output. And this idea kind of that every single output is an intervention in and of itself. This is really kind of the most recurring of our dilemmas, and it's one that all of us, me and my colleagues, all take part in collaboratively. So, unlike traditional academic work where there's a single output that's released and hopefully you're contributing to the discussion about an issue, in terms of the kind of digital accountability work that we do, there are many additional considerations that we kind of have to step through. So, of course, we have to ensure that our outputs are academically informative, that they're novel and this kind of thing. But we actually have to consider how the people that we report on will actually react to those reports as well. So maybe just to frame kind of as an example, I'll focus on malware work. And I think a malware work, not necessarily commercial malware, just any malware operator in general, because I think it is probably the least ambiguous in terms of ethical dilemmas. Because in the case of malware work, there's a very clear harm that's being done, and there's an actor that's basically perpetrating it, and we're reporting on it in this instance. So in the example, we have often observed actually a lot of changes in operator behavior after publishing certain reports. So these are changes we can essentially measure. Infrastructure, for example, I think the most obvious case is we'll release a report, and up until that point, we would be observing the operator's behavior one way or another. So we'd be somewhat familiar with the regular cadence of work that an operator has, and we could observe changes in the operator afterwards after publishing a report. So these are things that we can measure. So we know that there's an impact, and we know that when we report on certain things, there's a reaction to it. And so there's kind of this balance of things that we have to consider. So I think paramount is the security of those that we work with. So I think a lot of people think about researchers and research subjects as being the most evident in this case, and it's certainly true. But I'm also including researchers and ourselves in this case, because within this kind of work, I think, unfortunately, there's a lot of cases where there's personal attacks and things like that that target essentially the researchers that undertake this work as well. So something we wanted to flag. And the other case is we have to actually balance this responsibility of informing the public about issues. So this most presciently and basically improving overall user security. So in the lab, we have a obligation to disclose. We feel like we have an obligation to disclose certain security flaws to vendors, for example. We also consider, much like the previous speaker, that how the information in reports that we release can be used or misused by others. So there are positive and negative uses of information in a report. So we consider not only the positive impacts, policy changes and things like that in an output, but also the negative ones. So for example, if we publish an IP address, we're not likely to publish technical details about flaws against that specific IP, as an example. So, and we're very careful in technical descriptions of things. So basically, when we consider an output in general, we think of it sort of as an intervention. And I think the other thing we have to consider is also that we're not actually undertaking a lot of our work to willingly improve the techniques of the people that conduct a harm we're reporting on. So there's kind of two roles for any of the outputs that we release, which is that it informs users, but it also informs the operators and of the kind of things that we're reporting on. So basically, this kind of list of issues that we deal with is kind of the perennial dilemma, I think, in a lot of our work, where we're all having input in and we have to go through each time for any output that we have. So this idea that there's that a report release is also an intervention and one we have to take seriously.
Thanks so much, Jakub. So again, this idea of transparency versus security, both of the users in general and of the researchers, has again come up in your words, and thanks for that. And now I turn to Matthew. Thanks for joining us, Matthew, for our first round, please.
Yeah, thank you very much, Tamar, and thank you, ESIL, and the organizers for the invitation. It's Matthew Gillett, working at the University of Essex as a senior lecturer, and one of my portfolios there is running the Digital Verification Unit, the DVU, which is a group of around about 25 students, mainly, who conduct online remote human rights violations investigations. And so obviously the work is very dynamic, it's fascinating, it's very immersive for the students. But it does throw up some interesting questions and some quite novel questions. And you do sometimes feel like you're building the train as you're driving down the tracks and in somewhat ad hoc manner. So, which is one of the themes I'll probably come back to. In terms of an ethical dilemma, the one that pops into mind, we were working on a case of alleged police brutality in Nigeria. And we were asked by the lawyers for the victims to verify a number of audiovisual sources. And at a certain point, when we were doing an initial scan through the videos, one of the lawyers said, "Oh, I know this. There was a quite publicly well-known media figure in one of the videos. Oh, I know her. I could just call her up and ask her who were the other people present and what was being depicted." And so for us, this threw up this question because we were providing effectively an expert report. But if we then went and started talking to individuals, would it change the nature of what we were doing from a sort of quite constrained, forensically focused review of a set body of materials to a more open-ended kind of investigation, including witnesses? And then, are we really equipped and authorized to be going and talking to people who could be witnesses? And this, several people were killed, so it was quite serious allegations. And what happens if we, in trying to make our job a little bit easier, compromise or somehow taint this witness, and we don't know if other authorities are speaking to her, if she's giving statements, and so create this kind of partial statement that's then a problem and a hot potato in different people's hands. So we ended up not doing that and just doing the verification to the extent we could with the materials we had. Of course, even though it was tantalizing and would have been very interesting to talk to a person anytime you see someone in a video depicted, of course, your instinct is that you do want to talk to that person. So that was one that came to mind, and you live and learn, and maybe in different circumstances, we would have looked for the possibility to broaden and open into a more full-bodied investigation, but that brings its own host of difficulties when you're dealing in a kind of student-bound circumstance, and we're not really capable of conducting proper police-type investigations. So yeah, thank you very much.
Thank you, Matthew. And that really takes us to our next round of questions, because you really bring up this question of how is the conduct of online open source investigators work regulated, right? What guides your work? What do you turn to when you face these dilemmas? How do you, are there any ethical professional frameworks that you turn to? Are there any legal frameworks within your domestic jurisdiction or internationally that you feel like you can rely on in deciding these questions about what you should or shouldn't do, what you should or shouldn't reveal, who you should or shouldn't approach, and how to protect your own security in doing that work? So here I'll start with Siena, please.
Hi, I'm Siena, Senior Legal Advisor at the Citizen Lab. Thanks very much for hosting us. So I'll speak a bit more generally about digital threats against human rights defenders, dissidents, other members of civil society, and not just open source research, but hopefully this is still helpful. So there are 3 ethical and legal frameworks I would just want to mention at the outset that might be useful for discussion in this webinar. So the first is, in the context of the work at the Citizen Lab, the framework of international human rights law is very important, is central to our work. First of all, we work at the intersection of digital technologies and human rights, so it often gives a scope to the kind of work that we think is within our mandate. But it's also very useful, I think, in terms of understanding who we want to enroll in our research, so case selection. So it gives us a sense of sort of the framework within which we want to do the research. It also helps us evaluate and understand more objectively state behavior and sort of contextualize state behavior. So when we publish reports, it's not just a technical summary, but we often try and include some context so that people can understand sort of the context in which a form of digital targeting is taking place. And international human rights law is really sort of the standard framework that we use. Another critically important framework, because we're academic researchers and we work at a university, everything we do falls within the scope of a research ethics protocol. So this is, and I think this is an incredibly useful document outside the academic research context as well. It requires us, the process essentially that it requires us to sort of pull together a framework for research that takes into consideration the security of the research participant, the security of the researchers, issues around data protection, confidentiality, and informed consent, and especially informed consent to be, for example, mentioned in the research report associated with the Citizen Lab. So this is a very, everyone who works at a university will be familiar with this. But I think this is a really helpful framework for sort of thinking through and weighing different ethical dilemmas. The framework is as good as sort of the reviewers who review the protocol that we submit, sort of how thorough they are and how much they sort of understand both the research practices, the research context, and so on. So I think in general, it's quite good, but there can always be more improvement in terms of sort of ensuring there's sufficient expertise in the reviewing board to sort of really dig into the research methods and the research context. And the last framework I'll mention briefly is domestic law, of course, is a necessary framework to think about when you are doing this kind of research, in particular not infringing on domestic law in a way that would lead to liability for researchers. But it is very much a double-edged sword. And one of the examples that we had mentioned in our article was the Computer Fraud and Abuse Act in the United States. So there recently, the Department of Justice announced, I think it was 2022, a new charging policy that they would not charge good faith hackers under this statute. But of course, this is something that is highly discretionary and could potentially be reversed. So domestic law is helpful in terms of setting some boundaries in terms of what research can and cannot do. But it can also be a double-edged sword in the sense of it may be used, of course, to silence researchers. Similarly, domestic law goes both ways. It sets boundaries, but it also provides potential opportunities for companies who are being subject to scrutiny by researchers like us to hit back, for example, with defamation suits. So I think there's a lot to unpack there. So in short, I think the main sort of conclusion we drew from our article was that there is no sort of like one size fit all solution. There is no single sort of legislative framework that we refer to that says, this is how you can act, this is how you can behave, this is sort of how this research happens. It's very much sort of based on a mix of legal frameworks, ethics, intuition, and I think a huge part of the lab's work, at least, is the collaborative aspect, right? So we're never making decisions in isolation. One researcher is sort of on their own, weighing all these like big ethical dilemmas, but it's really a group, a team effort. And sort of, I think Ron will speak a bit more about this, but the point that we really wanted to put forward is, I think, and this is great to start with this, there should be more forums for this type of discussion, sort of at a global level. So not just between researchers, for example, working within the lab, but sort of across different institutions, academic and non-academic, Canada, the US, and of course elsewhere. So hopefully we can see more of that going forward. I'll leave my comments at that. Thank you.
Thanks so much, Siena. I think I failed to mention that Siena, Jakub, and Ron, and also Alexa had each had an essay in the AJIL Unbound symposium, and these were their topics. And one of the things you mentioned in your essay, Siena, was exactly this idea of having a community, both to engage in peer review of findings and to have sort of somewhere to bounce your thoughts and dilemmas. And I think that was one of the most important and interesting points. So thank you again for that. Alexa, to you.
Thank you. And I think a lot of what I'm going to say is going to underscore what Siena just said, because it seems like we actually have some overlapping ideas about kind of how ethics can work in this space. I might start by just underscoring that there's sort of 3 different characteristics of digital open source investigations that I think really inform different ways, potential ways forward. One is the multidisciplinary nature of the work. And so having to think across disciplines, what is an ethical approach to this? Second, that it's multi-organizational, as was already mentioned. So we're often having to figure out how to communicate information securely across multiple organizations who may be very geographically dispersed. And then third, it's very multi-generational. And I bring that up because I find that a lot of the war crimes investigators or the investigative reporters that I work with who have decades of experience have a very different familiarity with digital technologies, often, not always, but then some of the younger generations that we're working with, particularly the 18, 19, 20-year-olds who were born and raised with kind of a smartphone at their fingertips. So I think there's also a need to really bridge all of those divides and come up with a cohesive way forward. In 2017, I started teaching a class of law students on kind of conducting digital open source investigations for legal practice. And I remember we had just been looking at Facebook and how to get under someone's Facebook page and get their ID, which is how you had to do it back in those days. And then, there were a number of different ways to get additional information about that person. And one young woman raised her hand and said, Professor Koenig, but what about the ethics of what we're learning how to do? And ethics, thankfully, has become kind of a more common conversation, I should say, today, but it really wasn't then. And I had a moment of panic going, oh, shoot, I really haven't put the thought into this that I should have before we started working in this space. So I began furiously mapping all these different ethical frameworks that could potentially relate to what we were doing. I looked at journalism. At the time, what they were talking about in 2017 was whether it was ethical to take a video or a photograph someone had posted to Twitter and just use it in your reporting, as opposed to getting some kind of informed consent or, some kind of permission, but it was really about the intellectual property rights. It wasn't so much about the security considerations. I looked at law. Of course, legal frameworks really vary by jurisdiction, so that wasn't particularly helpful. Here in the US, the overriding concern is zealous advocacy for your client. That often isn't working as a check with these methodologies. And then the third that really seemed relevant that Siena already mentioned was sort of the institutional review board, social science research ethics frameworks, which had some guiding principles, but I think often weren't well tailored to really answer practical questions about how to move forward when you're facing an ethical dilemma. So with Sam Dubberly at Amnesty International and also with the University of Essex, actually quite a few people, we began hosting a series of workshops in London and Berkeley and other places to talk about some of the dilemmas we were increasingly facing and how to begin to approach them. Now in training war crimes investigators, where we've begun to land is I will usually suggest first to know what the relevant law says you can and cannot do, so that if you break the law, you actually are aware of the ways that may be harmful to you, to the people you're trying to serve, to your investigation. Second, once you know what the relevant legal framework is, to think through what your professional framework says. So for lawyers, for example, it can be radically different than for a war crimes investigator versus a journalist. Journalists generally cannot disguise their identity. So even the use of a sock puppet or a made-up identity is not necessarily going to be on the table. A war crimes investigator or someone who's working in a high-risk environment may feel radically different about that because of the security of the people that they're trying to protect by protecting their investigation. So, and then the third, when those both don't provide pragmatic answers, I think what we've seen across these different disciplines is sort of 3 major values bubble up. And for lack of better terms, I think what I've begun to call them is security. So thinking through the physical, digital, and psychosocial security of you, your team, the people you're trying to serve, the communities you're working with, et cetera. Second, dignity. And I think that brings in what Siena brought up, which is the international human rights framework, because dignity is sort of the core principle of that. For example, if you're working with sexual and gender-based violence material, how are you communicating that information? Who has access to it, et cetera? Also, how do you recognize the work, the often invisible labor that goes into these multi-person investigations? Are we just giving one byline to one rock star journalist? Or are we acknowledging the 30, 40, 50 people who may have really contributed quite a bit of time to make this investigation possible? So just two examples. And then the third is accuracy. I think because these are a set of methodologies for which many of us are trying to increase legitimacy, it's really important to make sure that we're getting closer to the truth and the facts on the ground, as opposed to further from them by showing a bunch of shiny, sexy things that almost look like magic to people who don't know those principles. Maybe the last thing I'll say is, of course, in 2020, we released with the United Nations the Berkeley Protocol on Digital Open Source Investigations. That was an attempt based on interviews with more than 150 people from very different sectors of practice, a number of different workshops to work on really contested areas of how to move forward, to come up with principles, methodological, professional, and ethical, that could be a foundation for doing this work. Now, the challenge is you have to still have standard operating procedures or whatever your processes are that sit on top. It's not prescriptive around that, but it's a beginning place for conversation to begin to build those workflows from the ground up. That's just been translated into all of the languages of the United Nations as of last month and is now available on their website. Thanks.
Wonderful. Thanks so much, Alexa. Matthew, what do you consult with when you work with your students or otherwise? What are the frameworks, ethics, legal, that you can turn to and to resolve your dilemmas?
Sure. Instead of replicating some of the frameworks that have already been mentioned, I'll mention from a slightly different perspective, because I used to work at the International Criminal Court there, conducting mainly as a courtroom lawyer, but also quite a fair amount of investigation. I can't help but think about admissibility and appearing as an expert witness. If any of the people here or any other individuals involved in their projects end up submitting materials that are used as evidence in an international war crimes trial or other atrocity trial. And so from that perspective, it's been very interesting. And with a colleague, Wallace Fan, we looked into this issue and found that the framework at the international criminal level is extremely broad brush, sparse in guidance. There's no specific technical parameters that would differentiate between a doctor or a DNA expert and a, for instance, digital open source information expert. So there's no sectoral guidance at that level, which I think is problematic for the judges, because I think digital open source information does present its own challenges. Now, I should say I'm looking at this from the perspective of classical legal sources that are reliable, that are applicable at the court under Article 21. And I think guidelines like the Berkeley Protocol can eventually develop into that kind of legal source that the judges could actually rely on. But as it stands, when they sit down to decide who is and who is not an expert, they have the general test, which is just based on jurisprudence of a person with a specialized skill or body of knowledge that can assist the chamber. And beyond that, there are some technical requirements about how they disclose their reports, the fact they can be jointly instructed. There's almost nothing in terms of ethical obligations. And if you look into the jurisprudence, you can find, for example, there's an Intergander decision saying that experts must act with the utmost neutrality and objectivity. So that's very interesting when you approach an investigation or a brief that you're usually going to receive from what potentially could be one party to proceedings, maintaining that objectivity. And even if it's one side to a conflict who ask you to look into various events, thinking about, should I reasonably look at this from an objective perspective as to any potential indications of torture and social media accounts, or should I follow their brief and just be prepared to explain, well, that was the brief I was given? So I think approaching from that perspective creates another set of questions in your mind as to envisaging, if I was sitting on the stand being grilled by the opposing counsel, the opposing lawyer, saying, well, what do you mean you only looked at one side? How can you express an expert opinion? And as an expert, you do have the prerogative and the benefit of being able to give your opinions, your views, not just what you saw and heard, but what you actually think based on your level of knowledge. How can you decide that, for instance, there was a disproportionate number of, I don't know, attacks committed by this one party if you didn't look at the other party, and shouldn't you conclude that both equally disproportionate, etc.? So coming from that perspective can be quite interesting and I think concerning as to the lack of specific guidance. And I hope that some of these initiatives that have been mentioned at the various levels can start to filter up to the judges and get adopted in jurisprudence, and maybe eventually as part of, for instance, the judges' rules or the regulations of the court or similar. Thanks.
Thanks very much, Matthew. And our last round, or the last round where I'll be asking the questions, and please, this is another opportunity to invite the audience to drop your own questions in the Q&A function. We said we'd discuss what we might think as the way forward in providing these better guidance and support for researchers in tackling moral dilemmas, and even moreover, creating a global institutional or professional or legal framework where these issues could be addressed. Now, Matthew, if I could come back to you, in your work, you've suggested how the ICC could approach the use of digital open source evidence while still maintaining this rigorous fact-finding standards and due process and fair trial rights. And you've just now discussed the role of experts. What about judges? Is there anything that we should be thinking about improving their ability to assess this type of evidence and critically evaluate them? Or what else would you sort of imagine in terms of ways forward?
The judges should definitely benefit from training from the digital open source community as to terminology, as to practices, as to likely outcomes, what's realistic. I think from my experience, some of the judges are surprisingly au fait and good at technology, and some are not. And that's just probably a reflection of typically the judges are going to be older. They're often coming from backgrounds where they've spent a long career looking at law books and not necessarily looking at social media platforms. And so, as mentioned earlier, they won't have that same familiarity as an 18 or 19-year-old. So training, familiarization is extremely useful, and also open dialogue. Obviously, you can't specifically intervene halfway through a case by telling a judge, oh, I was listening to the evidence you were hearing the other day and it's wrong because of this. Behind the scenes, there can't be that kind of back channel. It has to be done in a transparent and objective way. But the more there's this ongoing dialogue, the better, particularly given the dynamic nature of these platforms. And for example, we're seeing all of these AI-produced images that are now emerging, which then requires a certain level of expertise. And in some cases, they're still quite rudimentary, and you can sort of count fingers and see things that are quite obviously fake. But that's just going to get more and more sophisticated and more difficult to discern very rapidly. And so I think the more there can be an ongoing dialogue, the more there can be an updating in real time as to the state of the industry that will keep the judges on board. Because again, from that perspective, the worst thing would, in some ways, would be, well, the worst thing would be for someone to go to prison for a crime they didn't commit, and this evidence is being doctored in some way. But equally, if there's fake exonerating evidence that turns out to be unreal, and the judges enter an acquittal or partial acquittal on a charge, and it turns out it's all fake evidence, well, of course, that's not going to help the reputation of the International Criminal Court or any other body or a human rights investigation, etc. Thanks.
Thanks very much. Ron, in your essay for Unbound, you proposed establishing this organizational framework or some kind of institutional collaboration between digital researchers. Are we talking about this some kind of international society? How do you imagine this global community coming together?
Thanks, Tamar. Yeah, so a lot of the points have been nicely raised by others so far on the panel. So I think that what we tried to outline were some of the institutional and community support mechanisms that would be helpful, if not critical, to furthering digital accountability research. We already talked about research ethics boards. I think they play a key role, and they can help guide researchers around appropriate methods and approaches and how to think about best practices when it comes to securing data and data collection. In our experience, the Research Ethics Board at the University of Toronto has been very helpful, and we've had for many years a good ongoing dialogue with them. But I think, as my colleague Siena pointed out earlier, those type of peer review groups are only as good as the members that make up the committee. And so it's important that they're kept up to speed on the latest cutting edge research and methods and so on, which requires some institutional commitment. I would also flag that a couple of other aspects are important here. One is legal counsel. So at the University of Toronto, again, we have very strong support from the University of Toronto's legal counsel. Again, they need to be socialized into the risks and encouraged to support researchers with appropriate legal defenses because of the obvious mounting legal risks in this area. And again, this requires some kind of dialogue and advocacy with the university's offices and the relevant stakeholders, which is frankly challenged these days by fundraising and deference to industry, sadly, in a lot of universities. And we found that proactive engagement prior to any type of publication with the University of Toronto's council is actually very helpful. And unlike what I suspect is a lot of people's assumption, the university doesn't always put a brake on what we're doing. In fact, they often are quite aggressive is not the right word, but out there when it comes to defending academic freedom. Pro bono legal support should be encouraged, especially for those organizations that don't have the benefit, like we do, of a institutional legal counsel office. And there are some organizations like EFF that offer this type of support, but obviously it would be great if there are other organizations that could do the same for digital accountability researchers that can't afford or don't have that type of legal resource available to them. Tamar, you mentioned, building out this international community. That was something that we talked about at the end of our article. We think it's critical that international norms around digital accountability work are essential. And I just want to flag again the excellent Berkeley protocol that Alexa is responsible for, which can really serve, I would say this is the template for what could become a broader document, one that covers, for example, the type of spyware research or network censorship investigation that we at the Citizen Lab do, as well as other, new frontier areas of research. And with that, building upon that document, I think we could imagine a deliberative process that would allow people who are working in this field to exchange views, just as we are on this panel. And it would help address the isolation of decision-making between digital accountability researchers that are working in different silos. And it would also help when it comes to pushing back against laws that constrain research. And so if we had, channels and venues for these type of exchanges, more than just a one-off, a regular forum, it would allow us to track laws and regulations that are worrisome and find out ways that we can push back where appropriate and protect the type of research that I think we all agree is critical for liberal democratic society. So bottom line, digital accountability researchers need to stick together, be aware of each other's challenges and weigh in where appropriate. And developing an international normative framework around this, I think, is the obvious next step. Thankfully, we've got the great work of the Berkeley Protocol to build upon here.
Excellent, thanks. So that was exactly my question to Alexa as well. Could the Berkeley Protocol end up becoming a template for a more formal international document, normative guidelines? And is this something you might be interested in pushing, or are you hearing interest in doing something along these lines?
Absolutely. And, you know, I think we'd be thrilled to work with Ron's team and other teams to try to figure out what kinds of tools or guidance could sit on top of that to operationalize a lot of this in ways that are really hopefully impactful. I think the need to scale some of these basic underlying skill sets, but also awareness of the ways things can go wrong is going to be really critical. And I think that kind of gets back to the norm setting that Ron was talking about, and as well as others. So I think thinking through the scaling, I think thinking through incentives in our space is also going to be really important. How do we incentivize the careful work of having multiple working hypotheses or using peer review in ways that are a check on the quality of work is also going to be really important versus being the first to publish. I think we've seen these clusters of activity around breaking news events, and there's really a push to get that digital open source investigation out into the wild without always being aware of, you know, we don't know what we don't know. The gold standard in any investigation is trying to triangulate sources of data, whether it's physical evidence, testimonial evidence, this kind of digital content or documentary evidence. And I think sometimes there becomes almost an over-reliance on digital information where there isn't good access on the ground in ways that can be dangerous. I think one of the things that we tried to do with the Berkeley protocol was to really make it an iterative process of, we were working closely with the International Criminal Court. My colleague Lindsay was on the ground there, testing out portions of the protocol as it was being kind of built, and then bringing insights from some of those investigations back in. But again, that really has sort of a legal orientation, thinking about the collection and use of this information with an eye to eventual legal accountability. I think we need a translation of this for journalists, for other sectors of society that also use these methodologies, so that they understand how some of the really careful thinking that went into what are the risks and vulnerabilities gets translated into their day-to-day practice. One thing that we have coming out next month with a collaborative, as kind of a collaborative effort with Essex, with you know, Queen's College London, Witness, and a number of other organizations, is a judge's guide to the Berkeley protocol. So trying to answer some of the frequently asked questions that we get for judges and begin to translate it. But of course, having a document on paper or in digital space is not enough. There's still the real need to bring that into conversation. So kind of like Ron, and like others, I think it'd be really incredible to have a forum or have some other way to keep these conversations going, whether it's something as simple as RightsCon and adding on like a half-day session or full-day session, or whether it's, you know, finding some other mechanism. The last thing I might say is we're working a lot right now on a couple of different items related to sexual and gender-based violence investigations. I think that is notoriously in the war crime space a really difficult set of crimes to prosecute. And so I think issues of informed consent, how we even begin to think about that when it comes to digital evidence of sexual and gender-based violence, is really difficult. I have a paper that will be coming out hopefully in the next couple of months with a few colleagues where we've been grappling with that question for 5 years. I still don't think there's clear answers. I think we raise a lot of questions that I would love to be debating with others. And then we are working with the Institute for International Criminal Investigations to come out with a guide for digital open source investigators that complements their longstanding work on thinking about the ethical handling of sexual and gender-based violence survivors, where there's an assumption you're able to get consent, you're able to negotiate the terms of the interaction face-to-face. But of course, if there's video circulating in digital spaces, we're in a really different relationship to the survivor than you would be in boots on the ground investigations. So there's so much to do. I would love to be able to bring in more of the security considerations and really be thinking that through, just because I think there have been so many risks in that space. But anyway, looking forward to partnering anyone here who'd like to.
Thank you all so much. We have a couple questions, and I have a bunch of them myself. And if other participants would like to, please, there's still time to ask some more questions. But let me start with one from Gavin Sullivan, who asks, what specific challenges in your mind does the use of leaked, hacked, or scraped data pose for data-driven legal research in the area? And have you experienced, do you have any experience in how these issues have been successfully navigated with research ethics committees, or could you advise to those facing complex legal or ethical challenges in this area? So any one of you who would like to take that is welcome.
We nominate Siena on our side for that.
Uh-oh. No, it's a really good question, but it's a really hard one to answer in like a very snappy soundbite. So I think at the top of the answer, it's very a case-by-case situation. I really think it depends on sort of, you need very specific facts to answer this question. There is some guidance from research ethics boards in Canada, and I can post a link to sort of their note. But basically at the core is if there's still data in there, even if it's in the public domain, if that data retains sort of like a reasonable expectation of privacy, then you would still really need to seek an ethics review and potentially go through an informed consent process. And there are sort of like different versions of informed consent. You know, sometimes it's a written consent, sometimes it's oral, sometimes you can sort of make a case for not actually seeking consent from every person, for example, who might be identified in that data set. But I think here it really goes to the utility of having these research ethics boards. It gives you, I think for researchers, it's a level of protection, right? It's like you present your idea to a board and they're able to sort of assess and give you feedback on risks. And if they confirm that, you know, even though you're relying on leaked or hacked data, there is a good case for doing so and they approve, that's a pretty good green light. I don't think it's necessarily the only thing you should think about, but it's a useful process. Then there's also the whole question of domestic law and whether researchers might be attracting criminal liability if they use certain leaked or hacked data. Ron might be able to speak a little bit about that, but sort of course, some data might have very sensitive national security or defense related information that could actually lead to quite serious problems for researchers. But even there, the answer isn't necessarily don't use it, right? As we've seen in the past, the public interest case can be very strong in certain cases. And then I think there's like a set of questions that researchers can sort of work through in these situations. And I'll just give you like a few sort of high level ideas, not sort of necessarily the sort of all the questions that I would think about, but like what is the value of this data to the research mission? And I'm assuming a public interest research mission here and nothing else. What is the quality of the data? Is it accurate? Can you verify the source? What material ethical issues arise? So then again, like, are we talking about a huge set of a lot of personal information? Will cause harm to the people whose names or information is contained? Will it sort of encourage or condone theft or other illegal activity? And then, of course, what material legal risks arise? So that's referring back again to the domestic frameworks, or potential, I guess, even issues of a disclosure of confidential business practices or trade secrets. Then does the public interest in relying on these documents outweigh the legal or ethical risks? So there's once again a bit of a weighing exercise. And how will you be using the data? And then what sort of, if you do use the data, what security risks will be taken to sort of address how that hacked or leaked data might be used onwards. So there's a bunch of different questions, and I'd be happy to talk more about this, Gavin, sort of in another context, not to sort of belabor the point. But Ron might want to add something quickly.
Go ahead,
Yeah,
Ron.
just going to quickly add, if that's okay, Tamar, on this topic. We've had numerous firsthand experiences from myself being involved in the Snowden disclosures on the Canada side and a lot of thinking around that. But also there was an episode where a mercenary spyware vendor that we were doing research on called Hacking Team was itself hacked. And the hacker was asked, why did they do it? And they explained they were motivated by the Citizen Labs research. So the reason I bring this up, I think it's quite important that you're not seen, if you're an ethical researcher, to be condoning or encouraging what is essentially criminal behavior. And that becomes quite difficult because once the Hacking Team data was in the public domain, turned out to be very valuable for further research because there was a lot of information in there that proved useful in preventing harm down the road. And yet this was something that we had to navigate carefully in terms of not saying, hey, this is something that we explicitly encourage someone to do.
And if I can just quickly jump in as well, my colleague Lindsay Freeman wrote an article on hacked and leaked information as it might come into international criminal legal process. So I know she's been grappling with that. It would be great to continue this conversation on this because this is coming up in a very tangible way in a number of our investigations right now. We have one multi-organizational investigation looking at attacks on protesters in Iran. And of course, there was just a huge data dump of hacked and leaked information. I think even just there was that paralyzing moment of, should any of us even touch this? Is it secure to go to the website where this is being housed? Are we about to get infiltrated with really dangerous stuff? And I think when you're actually facing this, and yet you're realizing there's thousands and thousands of pages of content that are potentially relevant to your investigation, that you may even have an ethical obligation to know what's in that data trove. I think some clear guidance for open source investigators who don't have that kind of background of how to grapple with this could be incredibly helpful.
Thank you all for these comments. I have another question for you from, I hope I'm pronouncing this right, Kaha Kowalewska. And she's asking whether you see any challenges in proposition for safety valves stemming from the fact that OSINT and digital accountability research seems very accessible and very sort of something that could be reached without a lot of preparation, so that some actors can actually engage in that and then decrease the reliability of evidence out there unintentionally and negatively impact the community effort to produce reliable evidence. Ron, please.
Happy to take a crack at that one. I think that's a really important question, and I would phrase it, I would just elaborate on it a bit by adding in a wrinkle, which is that there's a lot of disinformation out there and a lot of people presenting as credible OSINT actually fraudulent information or information that is part of an influence operation. So all of this points to, I think, the need for what we've been talking about, which is a broader community of researchers that can speak not only to the ethical and legal issues, but act as a kind of, informal peer review body, a collective, if you will. I'm not talking, of course, in a formal sense, but just being able to weigh in and evaluate what are the measures that we use to authenticate information that's put out there that may be misleading. Of course, you want to encourage people to be digital detectives, but not everyone's going to be fluent in the type of ethical or legal issues that we're talking about here. So again, it's a tricky line to navigate.
And I might mention from the Berkeley protocol, I think that's why we came up with the 3 steps around verification, because what we tended to find was that people who got it wrong when they did this stuff were often skipping one of those steps. So the first step being to review any technical data that may still be attached to see if that gives you leads or hypotheses for where and when something was shot, to see if that information is consistent with what you've been told. Second is, of course, content analysis. And I think that's what we often think of as the open source investigation kind of set of methodologies of geolocation, chronolocation. Can you identify the buildings and the built natural environment in the background of what you see from satellite imagery or some other kind of reference material as a check on location, et cetera. And then third, the one that I think we're often most concerned about is source evaluation. So can you trace this back to the original posting? Can you identify who the source was for that posting and how reliable they are for this kind of information that they're purportedly putting out into the world? And that's the piece where I think we've particularly seen journalists sometimes trip up, and others is when you can't go through this, sometimes because they're working on tight timelines. But I think this is why I think that framework of accuracy, dignity, and security becomes so important, because it's that accuracy prong. I mean, we can see just even with what Russia has done, trying to imitate, say, a Bellingcat investigation and, grabbing clips from video games and stuff that really we know is not accurate representations of what's currently happening in the world. But in some ways, they kind of win on the disinformation front, whether we believe them or not. If we believe their investigation, their open source investigation with the little squares and the little circles, of course, then we believe them and they win. But if we don't believe them, I think what they're trying to do oftentimes is undermine our sense of confidence in these investigations. And that's something that really is incumbent on the whole community of practice to make sure it just can't happen.
Thanks, Alexa. Jakub, you wanted to add?
Yeah, just really quickly, I think it's a great question, actually. And it's definitely a challenge and it's definitely a problem, but it's also a benefit because this kind of work is accessible. The other thing I wanted to add is that in basically when you're publishing outputs and doing technical reports and things like that, there's an unintended side effect to having a section that you specifically can talk about the ethical considerations. And one side effect is that it becomes kind of ingrained in the community of practice within whatever community you have. So yet one positive side effect to this is when there's other reports and other outputs and that kind of section is missing as a result, it becomes a question that's put to people releasing those things. So I think it's one of those things, like, it is absolutely a challenge, and the way that we can address this is by having these ethical considerations more visible in the outputs and making it kind of like an accepted part of the tradition within the field.
So much. So I'm going to ask one last question from the Q&A, and then maybe I'll jump in with one of my own, and we'll use this also as a concluding round. So you can take either one of the questions or just say whatever you want to say in conclusion, and we'll do a round for all participants. So the question from the Q&A is from Derek Congram, and he says that we see a big movement to regulate forensic science as a check against small practice. However, do you think that it might actually be useful to have less regulation so that the field is more inclusive and provides more useful evidence from a broader scope or spectrum of investigators? And my question is about bias. So how do you think about tackling the issue of bias in case selection and in the availability of evidence, especially assuming that some parts of the world are less online or less available for open source investigations, et cetera? So how do we square this with the fact that a lot of this is done by international civil society or global civil society, and not there isn't a prosecutorial policy about what to investigate and what not. So that's one question I'd like to hear your thoughts about. And if you have any concluding thoughts, and maybe Matthew, we'll start with you.
Yeah, sure. I mean, at the outset, to repeat what Ron said, you wouldn't want to stifle that enthusiasm for digital detective work, and you can't expect people to become bona fides experts overnight. It takes work, and some of the most important discoveries have been made by people who haven't necessarily gone through any sort of formal qualification in this area. They've just built up the skills over time and made some major discoveries that have thrown a lot of light and been useful for international investigations. In terms of overregulation, I very much agree with the proposition that the regulation should be fitting for the sector that it's oriented towards. So what is appropriate at the domestic level is not necessarily what should apply at the International Criminal Court, for example, because they are dealing with all different cultural backgrounds, scenarios, different developmental levels of economies and societies. And if they try and impose a one-size-fits-all standard that, you must involve this many layers of peer review and you must involve this technology, that's going to be inherently exclusionary. And so you have to have a flexibility. At the same time, I do think guidance is needed where people are going to be intervening in legal proceedings. So I'm not saying that all investigations should be restricted by these same standards, but if they are planning on this or being used in legal proceedings, then there's particularly criminal proceedings and there's somebody's liberty on the line, then standards in terms which have been mentioned are set out in some of the documents that have been raised. But in terms of transparency and replicability, so at least the opposing side being able to essentially recreate the discovery investigation you've done, ideally if you have a trail, if you've saved searches, etc., so that they can find if they achieve the same results, and if not, investigate as to why not. And I think that will help, and it relates, and this will be my last second remark, that to insulate against ideas of bias, because inherently in a dynamic field, there are going to be allegations of bias. There are going to be attempts, as Alexa mentioned, to instill intention and bias and undermine certain investigations. And so at least if you're transparent with the limitations that you're working within, and you reveal, for instance, this is the level of certainty that we approach things on. Maybe it was quite a low level for fact-finding. That's fine, because you've been transparent, and whoever decides based on that to take it further understands what you did and what you didn't do. Thanks.
So much, Matthew. Jakub, concluding thoughts?
No, I don't have any specific concluding thoughts, so I'll cede to my colleagues. But I'm just surprised how much wisdom there is about these kind of issues, and how much depth there is in this discussion.
Thanks so much. Siena?
Nope, but I think Ron had a final comment.
Ron then.
Okay, I just in terms of additional next steps, I think one that would be helpful would be something like a professional journal or a peer-reviewed journal that would be on OSINT methods and ethics. I don't know if one already exists, perhaps, but either that or a professional track in an academic association would be helpful. And Alexa would be the obvious lead editor of such a journal or to head the association. In any event, I like Jakub said, I'm really into this topic, and I think it's something that we should, continue in some manner. So I really want to thank you, Tamar, for shepherding this process leading to the special journal and this discussion.
So much. Alexa, final words.
Well, first, thanks, Ron, for your vote of confidence. That sounds like an exciting effort, but definitely one I would love to see how we could all pull together to make possible. I love how these questions dovetail around regulation and bias, because the way that I see regulation potentially being its most advantageous is to help counter some of the biases that we do know. I agree 100% that we need the innovation and creativity in this space, but at least a sandbox that has some guardrails around it so that we don't inadvertently hurt the people who are most vulnerable, who often aren't the people that are most obvious in terms of the investigators themselves. With the bias, I think oftentimes when we're talking about that and thinking about it, we're thinking about it across 3 different domains. And I have a couple colleagues and I wrote a paper on this, but one, the access bias. So whose voices are not being heard as we increasingly turn towards digital information for making sense of what's happening in the world. Of course, that's very gender, geographic, age-driven, et cetera, language-driven. Second, algorithmic bias. So the ways that algorithms on search engines can be distorting the information that you're actually to find when you're actually out there trying to find information. And what are the ways to check against that? And then third, of course, the human biases that we all have. There's more than 100 that have been documented. In what ways is that potentially distorting our interpretations of these information? So while, when we first started working on the Berkeley protocol, I was accused of trying to make the space less democratic. And it's not that at all. I think it's trying to get us to at least think and talk about some of the dangers that we may just kind of instinctually ignore when we're trying to get information out to the world with very good intent. But I don't think thinking we're the good guys is necessarily an adequate check on the quality of the work or the kind of information we put back out. The last couple things really quickly, with traditional investigators, war crimes investigators, I think there's still a relatively low risk of the digital information driving the train. I think most of what I'm seeing, at least from my vantage point, is the use of this digital information as leading to other sources of evidence, like what witnesses were present, what physical evidence may exist, et cetera, or as corroborating information to what witnesses are saying happened in their communities. But then we have a few examples where it did play a role as primary evidence or base crime evidence that I think we're going to need to increasingly pay attention to and make sure that's not distorting what cases we're actually selecting. With the kind of more journalistic sector, I think we have to be really careful about not starting to have a bias towards visual information. Right now, that's really dominating the digital open source investigation space. And there are a lot of critical issues that just don't fall neatly into visual data like destructions of buildings, et cetera. And again, that kind of gets me back to the sexual and gender-based violence and other kinds of crimes that may be more hidden or more coded in how they're playing out in digital space. So I'd love to see more regulation in the sense of having these kind of norms or as a means to push norms in the space that we're thinking very critically about these issues and how we move forward. Thank you.
Thank you all so much. So this brings us to the conclusion of this event, and I'd like to say a few thanks. First to AJIL Unbound and to Professor M.J. Durkee, who was my co-editor for the symposium, and the various contributors to the symposium. Thank you to ESIL, Veronica Fickfack, and Maria Grazia Lucena. Thank you to the 3 generations of digital human rights research project, Professor Valshani and the project administrator, Gali Pearl. And last but not least, thank you to our speakers for a really fascinating discussion and to the audience for being here today with us. We hope to have the recording of this also published, and we'll let everyone know as we did for the panel itself. So thank you again, and have a good rest of the day.